Hello, I'm Edward Jones. I'm the admissions tutor at Leicester Law School. In this video, we have a consultation with one of the many legal experts who you'll work with at Leicester Law School. Dr. Catherine Wade is a medical law expert who will first of all take us through some relatively complex law and then help you examine whether this is appropriate law. So you'll be looking at it in a critical way. At Leicester, we have a long history of being at the forefront of legal research, developments and reform of law. So this is a snapshot of the approach that we take with your learning. So over to you, Catherine.
Hello and welcome. My name is Dr. Catherine Wade and I teach medical law, family law and bioethics here at the Law School at the University of Leicester. So I'm going to be leading you through this session called Subject Snapshot. So the idea behind this session is to give you an insight into what it's like to be taught a particular legal topic here at the Law School. And the title of this topic is, Should Adolescents be Allowed to Refuse Medical Treatment? So this is the topic that I teach on the module Medical Law, and this is an optional module which you can take during the LLB here. And the question here is about whether people under the age of 18 can refuse medical treatments. And these could be medical treatments which other people think are in their best interests, and they could also be medical treatments which are needed to save their lives. So I think it's a really interesting topic. My students are always really interested in it, and I hope you enjoy it. Let's get started. So, in terms of the learning outcomes for this session, I'd like you to be able to understand the law regarding whether adolescents can give consent to medical treatment. And then to understand the law regarding whether they can refuse medical treatment. And then I'd like you to be critical and to analyse whether you think the current law is satisfactory or whether you think it should be changed. So there are a number of competing principles in this area of law. One of the most important principles in medical law is that of autonomy. So the idea behind autonomy is that individuals should be able to make their own decisions about their own lives in line with their own values. But this is a bit tricky when it comes to adolescents because their autonomy is developing. So their understanding and their capacities are developing. And another complicating factor is that adolescents are usually part of a family unit. And so that family unit might have their own ideas about what is in the child's or the adolescent's best interests. And another issue is that any case that comes to court involving a person under the age of 18, in such cases, the court is guided by the welfare principle. So the welfare of that individual is the court's paramount consideration. So there are competing interests here. We want to protect the autonomy of adolescents, but at the same time, we might wish to protect their welfare because their autonomy is developing and they're in this developmental stage. So try to keep those competing principles in your mind as we work through this topic. So now we're going to look at, can adolescents under 16 give consent for medical treatment? So the law is different for those under 16 and those over 16, but we're going to focus on adolescents under 16. So the question of whether adolescents under 16 could give their own consent to medical treatment was answered in the case of Gillick in 1985. And it was a really important question because healthcare professionals cannot give a medical treatment to somebody without a valid informed consent. And so they need to get informed consent from somewhere in all circumstances other than emergencies. And so the question here was whether a person under the age of 16 could give their own consent to a healthcare professional, allowing them to proceed with the treatment, or whether the healthcare professional needed to get consent from a parent. And it was decided in this case that once an adolescent achieves a sufficient understanding and intelligence to enable him or her to understand fully what is proposed, then they can give their own consent to medical treatment. And there's no need to get parental consent, and there's no need to consult with parents either. And this test became known as Gillick competency. So once an adolescent is Gillick competent, once they have sufficient understanding and intelligence to understand fully what is proposed, they can give their own consent. And this particular case was about whether people under the age of 16 could give their own consent to advice and treatment in the area of contraceptives. Or would they have to consult with their parents and get parental consent? So the answer here was no, they didn't. They could give their own consent for contraceptive advice and treatment. But then the question arises, what if a person under the age of 16 refuses a medical treatment? So they need a particular treatment, like a blood transfusion, for example, but they will not give their consent. So this issue was answered first in the case of Re-Or in 1992. And this case involved a 15-year-old girl. She had a mental illness and required sedative treatment for that mental illness because she had psychotic episodes. She began to refuse her medication for these psychotic episodes. So the local authority sought a declaration from the court that they could provide antipsychotic treatment to her without her consent. So the local authority were looking after this child. So the legal question here was, did the healthcare professionals have to respect her refusal and not treat her? Or could they treat her anyway? And so Lord Donaldson, the judge here, he answered this question using the idea of keys. So he called informed consent a key. So a healthcare professional cannot proceed with a medical treatment unless they have a key. So this key unlocks the door to treatment. And Lord Donaldson said, a Gillick competent child is one key holder, but just because they hold a key, it doesn't mean that nobody else can give the healthcare professional a key. So the Gillick competent child is one key holder, but the parents are the other key holders. So if a child refuses a treatment, the healthcare professional can get consent from the other key holders, so from the parents or from those with parental responsibility. So he said the refusal of the Gillick competent child is very important, but it doesn't prevent the healthcare professional from getting consent from another competent source. So what this means is that a child who's Gillick competent can give their own consent. But if they refuse to consent, then the healthcare professional can get consent from their parents. So their refusal can be overridden. Now, we've had a number of cases where adolescents have refused medical treatment. So in Re-E, Re-S and Re-L, adolescents refused blood transfusions. Now, these were based on religious grounds. So here, the adolescents were of the Jehovah's Witness faith, and they refused blood transfusions because it is against their religion. Now, in some of these cases, however, the parents were also Jehovah's Witnesses, and they also wouldn't give consent for the treatment. And so then the issue was, could a healthcare professional proceed? Could they give the adolescent the blood transfusion? And the answer to that is they can, because they can get consent from the court, or they can get a declaration from the court that they can proceed regardless of the fact that they don't have consent from the adolescent or their parents. So the first three cases there involved blood transfusions, but the case of Re-M was not a religious refusal. The individual in Re-M, she was 15 years old, she refused a heart transplant because she said she didn't want to live with somebody else's heart. And this also happened more recently in the case of Hannah Jones, who also refused a heart transplant. In both cases, the adolescents changed their mind, but the question was whether the healthcare professionals could proceed even though these adolescents were refusing the treatment that would save their lives. And the answer was that they could. So basically, healthcare professionals can override adolescent refusals by getting a consent from their parents or from getting a declaration from the courts. So it basically means that while adolescents under the age of 16 can give their own consent to treatments, they cannot really refuse treatments because their refusal can be overridden. And so I'd like you now to think like law reformers. I'd like you to think about, what do you think about that law? So you could argue that number 3, the law should not change. So the law should remain the way that it is. Adolescents' autonomy is developing. Their autonomy is influenced by those around them and by their families. and we should not allow them to refuse treatments that are in their best interests and treatments that would save their lives during this phase of their development. And it's important to intervene in terms of their best interests and to save their lives. Or you could say, number one here, adolescents should be legally permitted to refuse all treatments, even if it would lead to their death. Now you could say here, and only if they're Gillick competent. So if they have sufficient maturity and understanding to understand fully the repercussions of not accepting the treatment, then they should be allowed to refuse treatment, and nobody should be able to override that decision. So their parents shouldn't be able to override that decision, and the courts shouldn't be able to override that decision, as long as they really understand the repercussions of their refusal, even if that refusal would lead to their death. Or you could take more of a middle ground and say that adolescents should be permitted to refuse some treatments, but only in certain circumstances. So maybe they could refuse treatments, but only ones which wouldn't lead to their death, for example. So they could refuse other treatments that are needed to improve their health or make their lives better, but never be allowed to refuse treatments which would basically lead to their death. And so I'd like you to think about that and think about the different reasons why adolescents might refuse treatments. Maybe they're influenced by their parents' religious views, or they're influenced by their friends, or they are more happy to take on risks than potentially older people. And so think about these issues, and I'd like you to just think about, would you change the law, or would you keep it the way it is?
Great, thanks Catherine. That was really interesting. Personally, I'd favour change. I hope you've enjoyed seeing how we examine the law and work by applying it to real life situations, and also consider the need for reform. And we look forward to seeing you all very soon.